This is a CBC podcast.
We have an update for you now on a CBC News investigation into the life of a 13-year-old New Brunswick boy under the care and custody of the Minister of Social Development, and that is, he is no longer in the minister's custody. The child's mother fought the province's bid to sever her parental rights on the grounds that he was beyond her control. Over a 5-day trial with her duty counsel lawyer, she argued the minister was not providing adequate care and that, in fact, her son was being traumatized. The situation is complicated and delicate, but in a unique 33-page decision, Chief Justice Tracy DeWere ruled ultimately the province must work together with the mother to help this child. I spoke to Julia Wright about this court decision last week, shortly after it came down, and here's that conversation. Good morning, Julia.
This is not an easy one to summarize, but maybe you can just try to recap the last 2 years.
So this is a boy diagnosed with oppositional defiant disorder, attention deficit hyperactivity disorder, and autism spectrum. And his resulting behaviors started to cause him problems in grade 1 and forced him out of school entirely within 5 years. He can at times have uncontrollable outbursts. He can be physically aggressive, say or do highly inappropriate things. But his mother knows the person behind those behaviors. She says this is just a kid who likes to rap, work on his bike, skateboard, play Xbox. But by the time he was 11 and already had the stature of a grown man, his mother was pregnant. His aggression and behaviors were beyond her control. Social workers feared for the baby's safety. And so the mother agreed to surrender custody of her son to the minister. And she thought this was the only way he was going to get treatment. The minister put the boy in what is called a specialized placement, which meant he lived alone in a provincially owned house. He was not with family. He did not live with other children. He was watched over 24/7 by staff who were hired by a company called Capital Family Services. They worked under the guidance of Sea Glass Consulting on how to manage the boy and provide some behavioral therapy. And after a difficult start, there was some improvement. Data showed the boy's behavior started to get better, but then it spiraled down again. Police were called numerous times, and he ended up being charged multiple counts of charges of assaulting his caregivers.
So Rachel, just to make sure that we understand this correctly, he spends 2 years living in this house. It's not going well. And now suddenly he is living at home. How did this happen?
Yeah, there's a few moving parts here. So when a child has been in the care of the minister for 24 consecutive months, an application for guardianship is made to the Court of Queen's Bench under the Family Services Act. And effectively, this is the minister saying to the parents, you had 2 years to fix your issues, whether it was drugs or alcohol, domestic violence, whether the parent was involved in crime or unstable housing. The parent has 24 months to turn things around and show that they can care for their child's basic needs. And so in this case, the boy reached the 2-year mark. The minister applied for guardianship, and that presented the judge with 2 stark options. Return the boy to his mother, or grant guardianship to the minister and extinguish the mother's parental rights forever.
It sounds like the minister lost.
The minister lost the application. After hearing from more than a dozen witnesses, Chief Justice Tracy DeWere concluded that a guardianship order was not in the best interests of this child. And she said this was not a typical guardianship case driven by the parents' issues. She said this was a mother who cared for her son, did everything she could to stay engaged with her son, and it was not a deficit on her part that the boy was out of her control. This is what the judge concluded. And there were several other factors that the decision goes into.
Like what?
Well, for one, the minister struggled to care for this child, just as the mother did, even after expending exorbitant sums and all the resources at the minister's disposal. The minister struggled, and the boy also challenged the staff, not only in his specialized placement, but was a challenge and tested the specialists in the Restigouche Psychiatric Hospital. In other words, the judge concluded he was out of control and it was not the mother's fault. And the judge laid out very clearly that the nature of the child's illness was playing a role in this. And I'll quote the decision here. I won't use the child's initials. She writes, "It occurs to the court that in the event the boy's medical needs were physical in nature, this situation might have been handled very differently. In the event that the child was a quadriplegic, and as a result of this complex medical condition, required mobility assistance, feeding tubes, ventilators, and supports of that nature, it would not be expected that a parent could manage those challenges on their own." And she goes on to say, and I'll paraphrase, "You would not ask a parent to give up custody of a child to get that child medical treatment. So why expect that here?"
So what exactly did Justice DeWare say about treatment? Who's in charge of that now?
She has directed the mother and the minister to work together, to follow the best advice of the boy's doctors, even if that does mean institutional care. And she says this is why she, in the end, granted a 6-month supervisory order. So it gives the minister authority still to supervise the child and the family to manage decisions affecting the child's security and development. Youth advocate Norm Bossé read the decision and commended her for it.
She said, "I have a third option. The child stays with the mother under a supervisory order." And you know what? That is the best decision she could have come up with. She could have just said, "Nope, I deny the application by the minister. There'll be no order issued from this court with respect to guardianship. The boy is to be returned to his mother," and left it there. I think she's a little more sensitive than that, and that's proven in her decision, which is just to be safe, there's going to be a 6-month supervisory order, and then we'll see where we are with his care. Puts the parties, the mother and SD and Health now, on notice that you're going to have to answer some questions at 6 months. So let's try to get it right. Everybody's being watched here.
So that was New Brunswick's child and youth advocate Norm Bossé.
So how does the mother feel about this?
Oh, she was crying when she read this decision. She is deeply relieved that her son won't be going back to that specialized placement. She believes he was traumatized there. He certainly was physically injured there because there were these altercations with caregivers who had to hold him down.
You don't know how hard it's been for 2 years getting shot down and pushed to the back and made to feel invaluable in this whole thing. And then to just be proven that I am fit and I am a good mom and I am capable. I just need help, just like I asked for. I'm not a child protection case, just like I argued for 2 years. I don't neglect my kids or abuse my kids. I don't have a drug addiction or, I'm not incarcerated. There's no reason I was treated like a child protection case. There's no reason why my child has been neglected and nobody's held accountable.
So, Julia, there's something else worth mentioning here. The mother has been unwavering in her fight for her son's proper treatment. Yes, she has been critical of the programming, especially the use of holds where 2 or even 3 caregivers had to physically subdue the boy. That happened a lot. She's been critical of the boy's segregation in this home. She's been critical of social development. She's been demanding. She does speak out. And the minister had argued these were reasons to sever her parental rights because she spends too much time criticizing the province. But the Chief Justice addressed this. She says, although sometimes the mother's demands for her son are unreasonable, sometimes her complaints are warranted. And while it might make the minister's job easier to have full control, this is no reason to issue guardianship and cut the mother out. She said, we do not take children away from their parents because the parent is hard to work with.
So here, Rachel, we've been talking about the family court decision. What about the criminal court matters?
Right. Because of these charges of assaulting his caregivers, he is now in the youth criminal justice system. And Youth Court Judge Julian Dixon recognized a few months ago that there were mental health issues here, sent him to the Restigouche Psychiatric Hospital for a 30-day assessment, and then again to determine whether he was criminally responsible or too ill to understand his actions. And all that led up to a bail hearing last week. And this is where I want to draw 2 arrows, if I can, like these 2 justice systems driving in opposite directions. In family court, everyone seemed to be on board to keep the boy in the hospital. The Chief Justice said everyone wants him to stay in the Restigouche Psychiatric Hospital, get inpatient treatment. Everyone, the mother, the lawyers, the boy's lawyer, everyone shares this fervent hope, she says, that he will stay there and get expert treatment. It's right in the decision that comes out June 17th. And then 4 days later, the boy appears in criminal court. He appears by video from jail in Miramichi. The prosecutor tells the youth court judge, yes, a bed had been secured at Restigouche, but the plan has changed because the Chief Justice rendered a decision against guardianship. The prosecutor said the department no longer had custody of the boy, that at a previous hearing the mother had argued against the boy going back to Restigouche. At the time, she felt that was just effectively locking him up for longer. And so the Crown writes up conditions for release, including a 9 p.m. curfew. Next thing you know, he's driven from jail down to the Fredericton courthouse, where he's picked up by his mother and his older sister, just about a completely opposite outcome.
So now this boy has gone from 24/7 supervision in the minister's care, confinement, this intensive treatment at the Restigouche Hospital, confinement in jail, and now he's home. Is he ready for this? Like, is this safe, Rachel?
The psychologist, Dr. Yves Turgeon, testified that the boy was not nearly ready to go back into the community. And he said there is a high level of risk that the boy will harm the people with whom he has the closest connections.
Like his family.
Like his family.
So what do we and what do you take away from this, Rachel?
Well, all along, this case has given us some remarkable insight into how New Brunswick really struggles with these highly complex cases. And we heard Dr. Turgeon say this boy is not alone. He said it is a sad reality at Restigouche that they work with many cases of children who are out of control. And he says what this boy needs is an integrated team, people coming together from social development, health, justice, the family, and that everyone involved has to realize that it could take a lot of work to achieve just a small success. He says there are no miracles in these cases, but because the gains are small, he says that's no reason not to try. And meanwhile, since the boy was found criminally responsible, there's still this matter of those charges of assault. He'll be back in court next month. And the mother says she's still waiting to hear from social development about how they're going to provide help and support as directed by the Chief Justice.
Rachel, thanks for this.
Thanks, Julia.
So that was my conversation with Julia Wright last week while I was working with the CBC News Atlantic Investigative Unit. You can read more about this story on our website, cbc.ca/NB.
For more CBC podcasts, go to cbc.ca/podcasts.